Yes, welcome to the No State Project here on my YouTube channel. It is the No State Project live from the fortified compound in Mesa, Arizona. Glad to be with you here today. Always glad to be able to do a live broadcast and streaming live here also. It is episode 60. It is, what day is it? It is April 11, 2018, which means we're only about 3-4 weeks away from Libertopia. So sign up at libertopia.org today so we can see you there. We've confirmed we're definitely having a jam there with Bill and the guys. So definitely check that out. It's going to be in San Diego at Humphreys by the Bay. And we should be able to get more shows in at the Oceanside with the Living Tea Brewing Co. But definitely check that out. The number you want to join me here on the big show is 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign. And before we get into the calls, because I am expecting Edgar is supposed to be joining us. Hopefully he's the Skype call that's on there in the queue now. But a couple of things before that. I'm happy to take dissent, but that doesn't mean I'm going to take abuse on my own show. If I want to be abused, I don't have to go on and do a live broadcast for that. I get enough of that with dealing with IRS agents and bureaucratic scum, government employees. I don't need to, and I'm not going to tolerate that on the show. You're more than welcome to call into the show and disagree with me, but if you're going to come off as angry as Whit did on Saturday's broadcast, then you're no longer welcome on the show. And I will go out and now say Whit is no longer going to be on the big broadcast, whether it's now or whether it's a Saturday show. So that is one of the things I wanted to get out. Coming on the show, the dissent is welcome, of course. That doesn't mean that we're going to allow you to do a Gish Gallop. A Gish Gallop is where you never shut the hell up. Now, some may accuse me of doing that, but it's my show. And I know last weekend I screwed up and didn't get the caller line hooked up. So, because it is a one-man broadcast here, there's no way to screen calls other than if you've called before. So if someone like Whit calls, I'll know when I'm not going to bring him up on the big broadcast. So let me know what you think in the comments there that Whit won't be on the show anymore. See if that's a problem. So the Gish Gallop, the idea of the Gish Gallop is to say so much. Let's say you do like one guy did, and let's say you go on for 5 to 10 minutes uninterrupted, and you're just making, let's say 20 different points. And then, you only have time or able to keep up and maybe jot down a few of them. And so you can't really address every single one. And the idea there is so that you can latch onto the one that I don't respond to and say, Bob, got him. I do like to take notes. So I don't know if we can read that there on the big show. I do like to keep notes and I keep track of what's happening. But I should not have to sit there and try and have to respond to 15 different points. And so someone like Whit, what he does is he'll throw a dig in. So he'll go on his narrative, which is also an objection you want to use if you're in court. That the witness on a direct examination is not supposed to get into a narrative. Shouldn't really even do that on a cross-examination, but it's more appropriate on a cross. But so when you throw a dig in, I tend to, I'll write it down because I want to address that. So if somebody's accusing me of using hyperbole, if you're accusing me of saying something that's not true, you don't get to make that comment about me on my show or just in general. You don't get to make a false claim against me, and I'm not going to address it. So then you turn around and accuse me of jumping all over the place. No. If you come on the broadcast, which all are welcome, you're doing it just to dissent, which is great. You will not be permitted to get into a Gish Gallop. And if you are going to make a false claim against me, I will address it. And I will absolutely no longer tolerate this crap as somebody accusing me of jumping all around and not addressing your actual point. If you want me to address the point, all you got to do is make the point. I don't need a whole long narrative. Just ask the question. If I need more context, I'll ask you for that. That's the way these conversations are going to go. And I'm telling you right now, Whit, I'm not going to take your calls any further. I'm going to drop you right off of the line. You're not coming on the broadcast any further. I'm not going to do that. You don't get to say, don't you dare. Okay? We'll have an exchange of ideas. But let no one misunderstand here. If you make a statement against me that I believe is false, I'm going to address it. If you have a problem with me addressing the points that you're making, call another show. Do your own YouTube rant about me. But I don't want to hear that on the broadcast. You know, and people, if you want to accuse me of not letting dissent on, the evidence is stacked against you that you can get on. But when we have a recorded bit of evidence that shows how angry you are and disrespectful, how insulting that you can be. So no, you're not going to get a chance to respond to this. And I don't care, because I was called crazy. And that's fine to say that I'm crazy, but you better back it up with some hardcore evidence. And I want to address the insult of those who don't actually have an argument and evidence. When somebody says to you, nothing I say will convince you, Mark, and if they say that to you, what they're saying generally is, I don't have an argument. All I could do is shout at you. And all I could do is say is how angry I am. I can say how crazy you are. And so when you put someone to task to make a moral argument, let's say within Whit's case, which you're not coming on the show, okay? Never. But when you're put to task by me, for example, and I want you to make a moral argument for the organization of government, just make it. Turning around and saying, nothing I say, Mark, will convince you otherwise. Oh, it's too bad. It looks like Edgar's not going to make it. Oh. Okay. Edgar's going to have to join us for the Saturday show, so we'll have him on there. But so what I'm saying is, yeah, when someone turns around and says, nothing I say will convince you, that's just their way of throwing their hands up. You got me. Mark, you got me. You're asking for a moral argument in favor of government, that as an institution, that as an organization, the way it's supposed to run, I can't possibly make a moral argument of that, because you, my friend, are a retard. You are so crazy. You are so jumbled in your brain. You are so caught up in your own ideas that nothing I say, no evidence, no logic, no nothing, is going to be able to change your mind. This is just a douche move. So instead of just presenting the damn argument so that we can have a discussion, instead you cut off the discussion and try to. I guess it's a really bad way of trying to gaslight somebody. That I can relieve myself of having a position, having facts, having evidence, having logic, having reason. I can excuse myself from that simply by saying that Mark is so close-minded, nothing I say will change his mind. And we've got evidence to the contrary on this show. So it's just too damn bad if you can't come on the show and control your anger. Now, you're not coming on the show, and that's just the way it is. We'll see if we could do better with dissent. Finally, I don't know if it's gonna happen or not, but Juan Galt, whose arguments and claims against me have taken up far, far too much time on my broadcast than is necessary. is supposed to be calling in for the Saturday show. So we will see. One of the things he claims that I get wrong is that I am dead wrong regarding prima facie evidence and the prosecutors arguing without evidence. That I have never debunked that. Yeah, I have. Because legal arguments are not entitled to a presumption of correctness. Just like the Supreme Court said in the Iqbal case, legal conclusions may form the framework of a complaint, but they have to be based on facts. And when you have prosecutors and judges coming flat out saying the prosecution doesn't need evidence to support their claim of jurisdiction, that's arguing without evidence. Yes, they're doing it with the blessing of the piece of filth criminal wearing the robe. True. But my reality is not dictated by what a judge says. I have at least I can't think of the word right now, but I can see beyond the judge and actually examine and analyze what the judges say. Now, what they say may be true and it may be false like anybody else, but to take their word as the absolute gospel truth and then say, well, Mark, you're wrong because prima facie, it's not the same legal. I know it's not the same legal burden, but they have to have the facts elicited in the complaint. They have to tell you what they are. And it's only a trial that's beyond a reasonable doubt. But to say that they don't have to show evidence, that they could just give you legal conclusions, and that's prima facie, legal conclusions are not prima facie evidence. Legal conclusions have to be supported by prima facie evidence. So I've addressed that issue on the show many, many times. Maybe if you call on Saturday, you can set me straight. But hopefully we can have a rational discourse, no Gish Gallops, and you could just we could address your issues one at a time and have an honest and open discussion, which is something that all dissenters are welcome to do. No, I'm not going to have you on the show, Whit from Gilbert. The episode, the last week's show is the last show that you're going to be on. So it's not going to happen. So let me get to the callers. Make sure nothing's muted. We've got a new caller here. We have area code 912. You're live on the No State Project. What's your name? Where you calling from?
Hello?
Yeah, you're on the show. What's your name? Where you calling from?
This is Richard from Atlanta, Georgia.
What can I help you with today, Richard?
Yes. I've been watching your show for a while, man. I love what you do. I love how you change things and flip it around on them. Man, it's amazing because I done tried some of your stuff, and I run into this prosecutor that's want to be a Billy Bad, and we got in front of the judge during the arraignment, and they told me to plead guilty or not guilty or no contest. I said, well, I'm willing to plead guilty now. I got my unsigned plea of guilty right here. And they didn't want to hear it. They said, that's for court. I said, well, jurisdiction be challenged at any time, right? No, that's only during court. They just shoved it aside. Then the lawyer said, the prosecutor said that since he don't want to plea, I'm going to plea mute for him. And I was like, no, I'm not playing mute. And, and she allowed him to push that through.
Did you object?
Did
you have to actually use the there are certain times where you have to use the magic word. You have to say object. So you objected. Okay, great. And they just ignore that.
Yep, they ignored it. And they pushed it through. So I got court May the 7th. I did ask for continuance. It supposed to be in last month. And I asked for continuance so I can get my my paperwork in, which I haven't got it from your site yet. I guess I got bad luck because my wallet was stolen, so I got identity theft, and he's charging everything on my card. So, but if I don't go in with the emotions, how should I handle it? If I go to court without the motions?
Why would you go to court without the motions?
Right now, my accounts are tied up. See, I have a card, but it's a temporary card, and I don't think it will allow me to buy anything off your website.
Well, you contact me off air, and we'll send you a copy, and you just take care of it when you can. Let's make sure that you're prepped and able to go into court, and all, you know. So you should also be doing the role playing, so that you can address these problems a bit better. Of course, like a lot of these, it may come down to how effectively you cross-examine the police officer. To where to where it's so bad they can't make it look good anymore. I mean, an example is when the prosecutor actually impeaches his own witness. And by that, I mean that he's saying that he's not qualified to testify. And they'll actually say that because it's such a well-known thing that jurisdiction doesn't have to be proven, that they actually impeach their own witness to protect them. I'm so sick of this idea that, and this is something you'll go through, Richard. The police officer will be more than happy to restate what happened when you cross-examine him. He'd be more than happy to say that, yes, he determined probable cause to give you a ticket. He had probable cause that the laws apply to you and that you violated them. And only an idiot would say that that was a statement of fact. That is a legal conclusion from beginning to end. And the idea that there's some magical thing with government, with legal logic, that when the police officer actually testifies to that, he is magically relieved of any obligation whatsoever to know what the hell he's talking about. All of a sudden, the rules of personal firsthand knowledge and none of that applies. And you're going to hear this kind of crap on May 7th. When you ask that police officer for the evidence he relied on to prove that those laws he said you violated actually apply to you, the prosecutor is going to leap out of his chair like his ass is on fire. He won't be able to object to your question fast enough, this piece of filth. And his objection will be that it calls for a legal conclusion that the witness can't testify. Are you familiar with this? Yeah. Okay. And for those who are new that are listening, what's so astounding about that particular objection, and trust me, this happens 99% of the time, you only ask for the facts his legal conclusion was based on. So tell me, Richard, why do you think they have no problem with the police officer claiming you violated the law, but only have a problem with your questions on the evidence to support that claim? Why do you think they have the problem with the evidence part?
Because it don't exist.
Yeah, they don't have
the
it.
Evidence don't exist.
Why don't they just take with the all-powerful Juan Galt, the all-knowing Juan Galt? Why doesn't he instruct the police officers to just say, I'm not required to prove that. I can testify to these legal conclusions and it could be used against you. I'm not required to prove it. Why don't they just teach the police to do that? Why does it always have to be the prosecutor saying they're not qualified?
So what if they say that the ticket is the item that give them jurisdiction and all that?
Well, you can break that down. Did the police officer have the ticket already written before he pulled you over? You see, and that's the kind of response that you should get from when somebody does suggest that the ticket is proof of evidence. And even if the cop was to say something, let's just say, just like in the one time that's been reported to me, like from Jermaine up in Alberta, that the police officer is allowed to answer. And let's just say that he says, "Well, the ticket." Well, we're going to go based on reason. We're going to assume that everything he's saying is a lie. If he's going to say that the ticket is somehow evidence proving that the laws apply to you, you have to ask him a question. You have to get him to clarify that. So your position is that the ticket has evidence on there proving that your Constitution and laws apply to me? Well, yeah. Then your next move, Richard, would have to be to ask him what on this ticket leads you to believe it's evidence proving your laws apply to me.
Simply because I was in their jurisdiction, I guess.
Well, the best that they can do is they can say, well, you were physically in Georgia. So you're saying that because I'm physically in Georgia, a written instrument called the Constitution applies to me. And then you just have to ask them, please explain exactly how this written instrument would apply to me and create obligations on me just because I'm physically in Georgia.
Wow. You're right.
Well, that's when you bring logic
how
and reason into it.
Okay. So how will I contact you, Offer? Just call that same number? Or
well, no, you email me.
Okay. Okay. Because I had a situation with another ticket that I fought before. And I went in court with the same thing, unsigned plea guilty. And I asked the judge, I said, can I have a fair hearing? Am I forgot how I worded it. Can I have a fair hearing if there's a conflict of interest?
Yeah.
And he was like, no. I said, well, who you work for? He said, the city. I said, who's suing me? He said, the city. I said, who's the prosecutor working for? He says, the city. I said, so how in the world do you think I can receive a fair trial if you are getting paid by the same person or the same entity that's suing me?
Yeah. Now, a better way to, before you get into something like that, is say, well, if you're acting on behalf of the plaintiff, wouldn't that be a textbook conflict of interest?
Mm.
And you just said, that if there was a conflict of interest, I couldn't get a fair trial, right? So when you do have to agree now that since you are admitting that there's a conflict of interest, that I can't get a fair trial from you.
Mm.
Now, somebody might say, well, now you're arguing philosophy, and you have to do that at the ballot box. And oh, what, because you said so? Oh, what, because one of the road pirates said so? One of the people who actually has a vested economic interest in the system itself? Oh, no, they wouldn't be biased and put out something so friggin' stupid. It's the ballot box. That's the thing. We have never been given the chance of whether there's going to be a government or not. Period. End of discussion. Mm-hmm. There is absolutely no historical evidence that a government came into existence by consent. The ballot box. A man is no less a slave because he gets to pick a new master every 4 years. Well, in some cases, yeah. So that's the way. Yeah, I'm glad you did that. It's surprising that you were able to get that in, because a lot of times, most of us tend not to have that much time to get into that. But you always want to, before you knock them out, you want to baby step them, since he is answering the questions. You want to baby step them a little bit better. So like what I had done. So after he agrees that you can't get a fair trial, there's a conflict of interest, and then he answers your question, and he's actually acting on behalf of a party. Then you can say, then get him to agree. So since you are acting on behalf of a party, wouldn't that be a conflict of interest? And surprisingly, though, Richard, sometimes they try to weasel out of that because they realize what you just did. And there are people who think that judges are just wonderful people. They're just trying to do the best to protect us. Okay. And there's a few bad apples, but generally they're good, honest people who sought positions of irresponsible domination over their fellow human beings. No. They don't like being cornered like that. They don't like being made to look like a fool. And they certainly don't like being exposed as the criminals that they are. And so they may want to weasel out of that. Just say, look, and you can go back to what you said. Sir, I am more than happy to plead guilty to here today. Mm-hmm. If you just answer the question so I know what the heck is going on. And it's okay. So I would have just added one more step to what you did, just so it's even tighter when you go for that knockout punch.
Yeah, because all he did was turn red. He looked at me, said, "If you don't plead guilty or not guilty," I said, "Are you threatening me?" And he, no. And that's when a cop came up behind me. And I told the cop, I said, I consider you as a threat walking up behind me like that, and I will defend myself.
Damn.
And he said, no, I was just trying to see what was going on. I said, well, you come beside me, because if you was on your beat and I walked up behind you, you would consider me as a threat. So I'm telling you, I consider you as a threat.
And it happened right after the judge said, got upset and said what he did. Because I've had it happen many times where all of a sudden there's cops standing directly behind me. I'm like, really? Is this what is what? Oh, I understand. My questions are scaring you.
Yeah.
Yeah, my questions are questions are so scary. Here's the thing, play it straight and the questions will only confirm you're a good guy. Otherwise, when you're a con man, it just is going to confirm that you are a con man. So that's the beauty of that. So I'm going to try to get some more calls, but get with me off air and I can get you that paperwork, and you just take care of that when you can. All right.
Okay. I got one quick question.
Okay.
My court date is on the 7th.
Right.
How much time do I have to get those motions in? Because I thought you had to give them 30 days.
Well, it certainly helps. But jurisdiction can be raised at any time. You can walk in on the 7th and challenge jurisdiction. And Brady material, there is no time frame on Brady material. So, and we're only asking, look, this isn't a murder trial. This is not some medical malpractice where the issues are very sophisticated. We're talking about a very simple traffic case where the evidence and everything should be in the record already. And it should be a file that, it's just a couple of pages. If the prosecution is insisting the Constitution applies to you and gives the cop jurisdiction to give you the ticket and gives the court personal jurisdiction over you, then it has to be in the file. He shouldn't need to have 30, 60, or 90 days to prove the laws apply to you. So on those 2 points, it doesn't matter, but get it in there this week.
Okay. I surely appreciate it, man. Keep doing what you're doing, man. You're helping a lot of people.
I appreciate that, and I appreciate the call. And let us know. Get into the No State Project Skype chat and start doing some role playing, and we'll get you prepped. We'll make sure we can get you prepped and ready for the 7th. All right.
All right. Thanks.
All right. Appreciate the call, Richard in Atlanta. And I go on record as saying that the Constitution does not apply even to people who call themselves government. Because they give the oath to nobody. It doesn't create any obligation on them. No, it is public relations. You have to accept reality. It is public relations. This idea that, well, the people, no. You're talking about a society that was deeply racist. A society that saw people as property, where women, an entire gender, had no say. And it didn't matter if you were white European. You had to own a certain amount of property. And the most important thing here is the fact that nobody had a choice in whether there was a government or not. The form of that government is not relevant. When you have people who are literally forcing you to give them money or they will hurt you, the form of that government or the public relations used to sell it, which is what the Federalist Papers were all about, was to sell it. It's relevant. What is relevant is that they are men and women. Back then they were deeply racist and misogynist, sexist, rich white men. They're the ones who pointed the guns at us, at the people back then. They had no choice. No choice. So if you think you can make a moral argument in favor of those who call themselves government, you have got an extremely difficult job, because you have to take the facts that are irrefutable, that they're just men and women forcing us to pay them. And you have to be able to make an argument that that is moral. I don't see how you can do that, especially since if you believe that the individual, like I am a criminal, if I force people to give me money, you have to be morally and ethically consistent in your argument. And you cannot do that. You cannot ignore the evidence. They own people, this property. Good Lord. Well, hell, you still got people today that think people are property. They just try to do it under the guise of anarcho-capitalism. Well, I own myself. Well, like Ayn Rand, the objectionist. My body's my property, and I can get rid of any foreign matter in my, even if it's another body. Your body is not a matter of property, and the one inside you is not property. Human beings, people are not property, period. You don't need to do that to make a moral argument against government and a moral argument against bullying. It doesn't have to start from this notion, I own myself. You are yourself. You are not property. Anyway, why is it in this day and age there are still people that believe that people can be property, even for them, in regards to themselves? I'm my own property. Oh, all right. We've got another new caller. We have area code 862. You're live on the No State Project. What's your name? Where are you calling from?
Yeah, it's the Blind Man Key from New Jersey, and this is my third time calling you, Mark.
Oh, you're from a different number, but okay. And I'm sorry, where were you calling from?
Yeah. New Jersey.
New Jersey. Oh, what do you got for us today?
Well, I don't have no good news. Like I told you, well, I don't know if you remember, but I was the one who was the lawyer told me just sign this thing, and I ended up in that drug court thing. But I called to the courthouse to find out if I had an open warrant or whatever, and they said yeah, and it's just for walking out of court. And then so I called to the court clerk, and I told him, I said, listen, I have no problem. I'll come back in, hand myself in, if you can give me the evidence that the constitutional laws apply to me. They didn't even want to talk to me. But another reason I'm calling you for is I spread your news around. I gave it to a friend next door who was mixed up. He got caught up in some kind of shooting charge where his friend shot somebody where he was there, and they was trying to charge him with attempted murder. And I gave him, I gave him some copies of my your motion to dismiss and things. And he went to court right in Essex County in Newark, and they dropped the charges on him. I don't have no proof of that. The only proof I have is he's standing outside when I talk to him. That's the only proof I could give you on that. And I have another friend named Joe who had a traffic ticket, and he's been using, I helped him with you helped him, but I gave him the paperwork. And after a year and about 2 months, he didn't get it all the way dismissed with everything, but they dropped it down where he didn't have to pay any fines or anything.
Hey, that's nice too.
So he did do some kind of damage control.
Yeah. Well, do you still have the warrant?
Yes, I do. I have the warrant. I told him if they give me the evidence, I'll hand myself in, and I'll hand myself right in, no problem. But yeah, I still have the warrant. It's just for walking out of court.
I think what I would do in that situation is I would file a motion to quash. You can use the motion to dismiss template, have someone, obviously, help you with that. And you just change it from motion to dismiss to motion to quash warrant, and you put in there that you want it done telephonically.
Okay. All right. I didn't think of that. I definitely didn't think of that. But so far, I sent in the motion to dismiss. Then I sent in the Brady request and discovery, and I sent in the motion for prosecutorial misconduct. I forgot to. I couldn't get back. I couldn't find the motion to limine. I couldn't get back to the email with that, so I never sent that one in. But yeah, I'll do that motion to quash. And you're doing great work. And I'm what I want to say is, I'm not scared of these people. Like when I get in front of the judge, I'm not scared of these people. Like I will let them know. The only thing you can do is put me back in jail. That's not going to make me not fight for my freedom. I'm not trying to go into slavery because you just said so. And like once it dawned on me what you've been teaching, you really opened up a light in my head, man. And I thank you very much, man. I appreciate what you're doing.
I'm glad to hear that. Thank you. I appreciate that. I do. I would, well, if you've already got those things in there, the judge hasn't made any ruling on them and the prosecution has not responded to the Brady at all.
Yeah, they didn't respond to anything.
Wow. Well, you may be looking at having to go. I would file the motion to quash, and if there's no ruling on that, I would look at a petition for writ of prohibition into the higher court, because you're being complete. If you're being completely ignored, you had no remedy there. They're just obviously not interested in, because look, even if you say that the motion to dismiss is, to quote, I think a prosecutor, gobbledygook. just deny it or strike it. But to not rule on it at all, that's bad. That's that, you know, because you're not being heard at all. Because due process at a minimum is notice an opportunity to defend. And here you don't have an opportunity to defend if they're just not going to take it seriously. At least deny it. See, and that's the thing for those who may not be aware, which is probably a lot of people listening to the broadcast today. Well, new people. You don't have a right to appeal a denial of a motion to dismiss for lack of evidence proving jurisdiction. You have to, you can't immediately appeal that, which is why you can do a petition for a writ of prohibition. And, you know, judges know that. So if they just say, well, I'm just not going to rule on your motion at all. And what they like to do is wait till you're physically in the court. And now they can threaten you, and they can threaten you and carry out that threat with a psych evaluation. And they can tell you, you can take your jurisdictional challenges and you can pound it because we're going to put you in jail. And then they're going to forget your name the moment that you walk out of there. So anyway, you do have an option to do the petition for writ of prohibition because they're not ruling on anything. So I would still bring it in there.
I can get that on your site too?
Email me and I can get you a copy of that.
Definitely, I'll do that. And I'm trying to spread the word, man. I mean, it's a lot of people that I know who going through things, but they just, you know, they you know, they're still stuck in the box. They can't get past and understand what you're saying. And I'm like, it's common sense. But,
well,
you know,
it's not necessarily, it's common sense if you break it down and you discuss it with people logically, and you start from a point of agreement, and you say, you try, you know, because if you do it from a moral standpoint or ethical standpoint, it's fairly easy. I think people get it. It's just accepting that everything is a lie. Like we had a caller who had a dissenting call a number of weeks ago who just cannot accept that there is no government, there are no citizens, that it's just men and women forcing us, you know, to pay them under threat of a prison system, and that the Constitution is just public relations. But if we start from a point of agreement on the moral principle, look, if I was to force strangers to give me money, would you consider me a criminal? Yes. Well, what if I did something nice with the money for the people that I stole the money from? Would you still consider me a criminal? Well, yes, of course. That doesn't change anything. Well, isn't what we call government, aren't they just men and women that force us to pay them? And now you've got them in a very, you know, difficult situation. They either have to admit that, yeah, that's all, or they have to try to make an argument or show that that's not what that's not really all government is. And you're not going to pass that. You won't be able to do that. So there, it's just a matter of accepting what they already know. And people are going to fight you on that. It's people who, you got people who absolutely, no matter what happens, they're still going to support Trump and say, but Hillary. Really? That's your argument? But Hillary? So start with a point of agreement on the moral principle. And you'll nail them it's just like with veganism. You'll nail them every time if you go and make it a moral.
I'm even trying to get into that, Mark. I stopped all the meat and I stopped all the dairy. So I'm just eating fish now and all vegetables, man. You know, I go to like the organic store. I get somebody to take me and I get my vegetables and stuff like that. I'm going to try to stop the fish too, but you know, it's kind of hard, man. I love fish.
It's unethical. It's if you decide that you want to be more ethically consistent. That's all it comes down to. If you want to be, well, it could be a health issue too, because certainly eating fish is not a very good thing to do. But it's a moral issue as well as a health issue. But if you look at the moral issue, it's just unnecessary. It's wrong. It's if it's wrong to walk up and kick a dog, if it's wrong to be abusive to an animal, then killing that animal is the ultimate abuse. So it's just a matter of, so just look at it that way and don't beat yourself up. If you're not able to do it right away, let me do that.
Okay. I'll do that. Well, listen, Mark, you have a great day. Keep the work up, man. And I just want to tell everybody listening, your way is the way to go. And thank you very much. I appreciate you.
I appreciate, and Blind Man, appreciate the call and definitely get me off air. We'll get you a copy of the paperwork.
No problem. Thank you.
he's got a lot of crap going on there. I remember he's got a lot of issues there. Not to, but just and that's a direct quote from a prosecutor who said that my motion was gobbledygook. I mean, usually I hear, at least, well, the federal level, that it's legalistic gibberish, and it's why we've always wanted to call, and we tried at one point, judge wouldn't allow it, to call a English teacher, just a high school English teacher, to testify against the prosecutor because we filed a motion for sanctions against this jerk. That you may not agree with the motion, but it is wrong to say it is gobbledygook or legalistic gibberish. It's in high school English. Maybe that's what we should do. Oh, the ticket is gobbledygook. This is legalistic gibberish. You think a judge is going to accept that? No, we would be looking at a psychological evaluation. Now, I do want to get into the motion to stay that someone's requesting, but I absolutely have to get to risk management. So I'm going to get to another call. Okay, area code 302. What's your name? Where are you calling from?
Sean, calling from Newark, Delaware. I called you a few weeks ago, second time calling in.
Okay, you got a good news update?
Well, as far as what I'm doing in family court, I'm just waiting for my court date. Like I said, they've done threatened me with assault, imprisonment, all the rest of it. If I don't show up, it's on the paper. So that's theirs within itself. I don't do the appeals thing. I don't know how to do that stuff, but that's why I said I'm the guy, Lord Conchi. I'm also me, but on my phone, because of my business, that's what I use. And I forget that I'm on this phone sometimes. So I just said, forget it. I'll just call on this line. But, now you keep telling us to challenge them about the Constitution and how it applies to us. And I said that the Constitution isn't written for us. The Constitution was written by us for them. And it's their rules that they wrote that actually imply us to be able to do things like appeals, motions, and things like that. Because in all actuality, it's not on the people to say, well, can you prove that the Constitution applies to me? Because the Constitution does not apply to us. As a free human being, we all have the right to do what we want, which is speak, hold arms if we choose to defend our life and family and things like that, and so on and so forth. But if you read the Constitution, nowhere in the Constitution does it say what we can't do. It says what the government can't do. But it only says what we are allowed to do and what the government isn't allowed to do. So in all actuality, it should be the states that are challenging the Constitution, but they can't, because the Constitution is hand in hand with admiralty law, the other Constitution, the Constitution that the states are under by the bar. As we all know, they all have to take the bar exam, and that's directly related to the Queen.
They don't all have to take the bar exam, but this idea the idea that the Constitution was written by us, that's not true. The Constitution was written by a few dozen rich, white, racist, and misogynist, sexist.
Well, hold on, Mark, because I listen. I'm telling you right now. Okay, now I know that back then there was a lot of racism going on. I know there was slavery going on, and people were, and that's the reason that America is the only country in the world with anti-slavery laws. Other countries have rules, not laws. We have a law against anti-slavery. And if you look at it, the two respondents on the Declaration of Independence, if anybody, because I keep hearing people saying, well, the Constitution wasn't actually fortified because two of the people, they were forced to sign it and this and that, and they didn't really want to sign it. And then they try to use this as the Second Amendment and all this. No, if you do research, you'll see that they weren't arguing about the right to speak, the right to bear arms, or anything like that. They were actually arguing about slavery because they wanted to keep it. But now, if you also look back in history and remember the time of the war, you'll remember that, and you'll find out that.
Sean, this, and I want to address someone. I'm not talking like an SJW here, a social justice warrior. The point is, if you look at society back when the Constitution was adopted, women were considered property, just not to the degree that people from Africa were considered, that they were literally property.
And that's why I think we came to America, because we didn't want to be under Islamic law. If you look at all the wars from 1700 BC, a majority of them was started by Islamic law. All those countries over there were fighting Islamists, Muslims. And they were doing it because the Muslims were attacking them, taking their wives, raping them, all the other stuff that we know Islam is known for.
Sean, I'm losing time here on the show, so I'm going to have to go a little bit over so I can cover the risk management. You know, if I look at my own ancestors, I'm of Sicilian descent. I don't think that the Muslims were, attacking and doing what you were saying in Sicily. Not at that time, maybe 1,000 years before that. And then my other side, my Irish, familia, no, most of them were just, tired of the feudal system in Ireland and being controlled that way. And they got the hell out of there when they had an opportunity to live a pretty good life fishing in Newfoundland. So a lot of my family, settled there in the Irish Loop on the Avalon Peninsula. So I don't have enough time to start breaking down all this. It's quite a generalization, but it gets away from the very fact that the Constitution was written by rich white men for rich white men. It's not me being a social justice warrior.
It's for the people.
No.
Because again, when you read the Constitution doesn't take anything from the people.
That's not true.
What it does,
Sean.
What is it? Okay, out of all the Constitution, tell me one that takes something from the people. Give me one.
Okay. The power to tax.
There's no taxation in the Constitution. That's written by the IRS, and anybody that knows that that's IRS laws. There's no taxation written inside of the Constitution.
Yes, there is.
The only taxation, right, for government officials, not the people.
That's just not true. You'll have to call in an early, so we can get you earlier, because that's just not true. But I do.
The whole Constitution points at the government. This is what you can do. This is what you can't do. This is what they can do. They're allowed to do, and you can't hold it against them like have a gun. But they do because people agree to it. They show up to court. They don't challenge jurisdiction.
That's not agreeing to it. People go to court like you and like our friend Key and Richard.
Personal jurisdiction, you agree to it. When you don't challenge personal jurisdiction, you agree to it, and it's written that way.
Look, there's something going on. Wait, Sean. I don't want to have to mute you, and I do have to go here in a second. But there is a discussion being had recently, very currently now, as to police officers in New York they're trying to pass a law that they can't have sex with people that they arrest. And that's because a lot of people actually do recognize the power dynamic, that somebody who's under arrest can't consent to, even an adult, of course, we're talking about adults, that an adult can't consent when they are in such a power dynamic. And so it's the same thing when you're going to court. You are under threat, duress, and coercion. You are not consenting. Even if you don't challenge jurisdiction, you're not changing the fact that you're there under threat, duress, and coercion.
Legally, if you allow them to do anything legally in the court system, you agree to abide by legal terms.
No, you're not agreeing. You
are agreeing, because if you have a public defender, well, he's a lawyer. He cannot lawfully represent you. He can legally represent you. And there's a difference between lawfully representation and legal representation.
I don't have the time to get into and start questioning you on legally and lawfully.
Tell your lawyer to raise personal jurisdiction, and I can bet you he will not. Because he cannot. When you raise personal jurisdiction for him, he loses his legal power because he doesn't have the proof that he can legally defend you now.
No, I disagree with that, but I don't have the time to get into it. I'm almost out of time, and I do have to get another caller, and I have to talk about risk management.
Okay.
So give me a call on another day, but I appreciate the call, but make sure when you call back, you definitely have some evidence to back up what you're saying, because I've never seen anything to show that there's a distinction, a recognized distinction between legal and lawful. That's just some of the sovereign type stuff and Freeman on the land, and that it's the same thing as statutes aren't law. And here's the Supreme Court saying that, when the Supreme Court actually said unconstitutional statutes are not law. You got to take the whole quote, and you can't just pick and choose. Oh, they said a statute's not law. No, that's just not true. And legally and law, no, you can't agree when it's the government, because you have no choice. And even if you don't recognize that you don't have that choice, it's still not. You don't have to recognize that you have no choice to have it be against your consent. And that's the whole nature of fraud, is that you appear to be consenting, but you're not consenting to what you think you're consenting to. Things are being withheld from you. You're being lied to. So I'm going to bring Wonder Ann on. We got to be real brief because I have to talk about risk management. Welcome back to the show.
Hi, this is Wonder Ann. How are you, Mark?
I'm doing well. I'm low on time, so I'm hoping you have a good news update for us.
Well, the zoo called General Sessions in Greenville was just that. It was a zoo. I have gone into court before where we had to be quiet, sit down, and just stay still. It was like a big fraternity meeting, and what it was to really intimidate people to say, "Oh, I go with you. I'll let you plead for me," and all this other stuff. Well, I had a very quiet talk with my the public defender that assigned to me, and we went around and around. And he brought up an issue I put on the chat room about the fact what you were just saying about moral. And he said it's a moral this and a moral that and everything. And I said, well, what do you mean by moral? And what he got down to is you have to obey us no matter what, even if you're breathing. And everything you do in Greenville County, you have to obey. And I'm going, oh, that was interesting. And then I hit him with what the corporations were, the city, the county, and the state corporations. And I told him I don't belong to the corporation. I have proof that I never worked for any of those corporations. So I thought I was recording the whole thing.
I wouldn't get into that though. If they're thinking that their rules apply because you're physically in Greendale, did you say Greendale?
No, Greenville. Vill.
I have community on the mind, so it's not Greendale. Okay, I would prefer if it was Greendale. That would be a lot more fun. But if that's what their claim is, then they need to put the evidence on the table, and it's not necessary for you or me to be able to make to make statements like that, and because they don't give a damn. They'll run over you. It's just a lot more difficult for them to run over you if you're just trying to defend yourself by getting the prosecution's supporting facts. But so what were you going to say about what's going on?
Well, what ended up with our little private conversation was the fact that because neither of us wanted to work with each other, he was very willing to have the judge call a hearing so that I can get him out of my case or to have him of counsel only and not interfere with what I'm doing, because I have attempted to file things. Oh, no, you've already got a public defender. You can't file anything. So it's just a real stopgap. So I'm working around that. And we have found that none of the lawyers or the prosecutors or anybody is using their full name as they make us use our full name. So it's an interesting foibles that they're doing.
Well, the thing to hit is the prosecutor's claims of jurisdiction. So weren't you filing into the higher court a petition for writ, if I remember right?
Well, I have it, but I have no order. In that writ, you need an order. I mean, I was reading the document and trying to adjust it to it. I have no order. I have nothing. I have not even been in court. That zoo never quieted down. he finally told us that we could leave. I said, "Now you're not going to arrest us? Send me back to jail." "No, the prosecutor saw that you were here." And so that was fine. And I was, I had 4 other people there with me to be my witnesses, and we all left.
All right. Well, if you need a proposed order, that's fairly simple. If that's what you're referring to, if you need a proposed order to go, but even not having a proposed order shouldn't stop the higher court from issuing an order on the stay of proceedings. So, but I'm going to try to get another call before I talk about risk management. So, if there's something I can help you with, email me about it.
Okay, I will.
Right.
Thank you very much, Mark, for the thumbs up.
You're welcome. We'll talk to you soon. We got Alan in Canada. He's been on the show before. Welcome back, Alan.
Hey, how's it going? Oh, maybe I'll put my headphones in here for so you guys can hear me better. Oh, I didn't realize you were going to throw me on. I thought you were going to commercial or something.
No, we don't have commercials on Wednesday, but I am running very low on time because I wanted to talk about risk management because I missed that on last show.
Oh. Yeah, somebody was mentioning that in the Skype group. What's that all about?
Well, the risk management is something I'm talking about. Is trying to hold these judges and prosecutors and police officers accountable, because judges and prosecutors, even though technically there are exceptions to that they have absolute immunity, when in practical terms, it's impossible for us to get a suit into discovery against a judge or prosecutor. So, to get around that issue, and also with the police with their qualified immunity, the judges and prosecutors are covered by the city, county, or state's risk management insurance. So in the U.S., they used to have bonds. Now that they self-insure, which are then underwritten in some cases by real, private law firm, insurance companies. And so I suggested what we could do is we can file a claim for damages.
I didn't recognize what you were calling it. It's public hazard bond, right? Is what you're talking about.
It may have been that in Canada, but yeah, they used to have an employment bond here in the U.S. and they did away with that decades ago. And so if we file a claim for damages against the insurance, there is no issue of sovereign immunity because you're filing a claim against the insurance. And they are covered by the insurance policy, and you're not going directly against the judge or prosecutor. You're going against the city or the county or the state for the damage that was done by one of their employees. Because bottom line, a judge and prosecutor are just employees, in the same manner that a janitor is.
Well, that's true. I mean, it's just like car insurance, right? Once they get a few dings on it, they won't be able to get insurance, and then they won't be able to, work under their own bond.
We hope so. I don't see it as a matter of us getting any money. I just see it as maybe because and someone's asking me if I can name can I cite a case where this has worked, and I can't. We haven't gotten one through yet. This is something that is still in the theoretical stages. We're trying. We have someone in Texas who's going to bring it into court soon. My main objective. One second. My main objective in doing this is so that we can possibly get the prosecutor and judge into a deposition or onto the witness on the witness stand, so that we can question them where they have to answer instead of just screaming at us contempt or psychological evaluations. I want the prosecutor and judge to answer questions where they don't have the ability to call in the guards on us.
Well, and under oath where they can't lie either, right?
It's interesting that you say that because somebody had posted last week about that.
My thoughts on this, though, wait, before I lose it, Mark, my thoughts on this, though, are if you file a complaint with the Law Society, isn't that the same thing as making a claim on their insurance?
Well, it may work that way in Canada. I can't say with certainty that that they have the attorneys have insurance through the Law Society. If that's the case, then yeah, you're killing two birds with one stone.
Well, yeah, it's technically, it's an actual separate entity, but I think it's run by the Law Society, so it's all it's all in the in-house, right? Yeah. Well, yeah, I hear what you're saying. Yeah, and that way they can't come back at you and say you're trying to intimidate that man like they were trying to do to me, right? Because you're just going for their bond, right?
Yeah, you as long as you have the evidence, like, sort of like what we have with Frank in Saskatoon, where the judge he convicted him without a trial in a criminal, it was a tax evasion charge, and he convicted him on nothing more than Meads versus Meads. That, when you've got the goods on them and you can show that the judge has damaged you, and they can still claim that you're a sovereign citizen and all this other stuff. Yeah, but at least you've got a solid record to show that they're lying again. Here we go.
Well, wouldn't it stand to reason, though, if they're acting outside their mandate and you catch them at it, that they're not actually immune?
That you're technically correct on that. That's why I mentioned before, from a technical standpoint, there are exceptions. They won't recognize them. It's the same thing, Alan, when you look at the Anti-Injunctive Tax Act. There are exceptions to that. They won't recognize it. They're doing, the whole three monkeys thing, which is one of the reasons why that's on the back of Adventures in Legal Land. Not one judge at the federal level or in California, not one of them, because that's where we were doing them, has ever recognized that there are exceptions. And, I've cited it on the show before. I don't know it off the top of my head, but it's the Enoch case from the U.S. Supreme Court. If you can show that the IRS cannot prevail under any circumstances, then there's no bar to the suit. So it's the same thing if the judge and prosecutor act completely without jurisdiction and knowingly without jurisdiction. But get that through on a practical sense, and it's just not going to happen. So there are a lot of technical remedies that you have, but getting it through the court is another story.
Yeah, well, it's kind of interesting that you bring up this issue right now today, because when you think about it, this issue is pretty much the whole, in my opinion anyway, it's the whole underlying reason why there's so much corruption in the legal system in the first place, because there's no rule of law.
Well, it's
right?
immoral.
If these people were held accountable for what they're doing, then they wouldn't be doing such things anymore, right?
But the system itself is immoral. You're starting from an immoral and grossly unethical position. So when the foundation of the organization is immoral, you can only expect such things. That's only so. When you have people that are dominating others violently with no accountability, you can't help but have such results. That's the only result that you can really expect to have. And for anyone to say different just doesn't understand human nature or sociology at all. Hell, you don't even have to understand that. You just have to know it's a foundation of immorality.
You're right. It's definitely, like, deep down in the depth of it, it's just tyranny and oppression, right?
Well, you're in Canada. The law professor, he said it was a blunt assertion of power. Well, that's criminal. That's immoral. And so it comes down to, well, all right, now that we've educated some people about what the nature of it is, and it's irrefutable, there is no moral argument for government. What do you do about it? And that's
objection, Mark. Okay. Do you have any facts or evidence that I'm in Canada?
Well, I can only go based on the area code, but you can be on a cell phone. But their argument, and somebody made the point here on the chat. They were saying something, and I've been neglecting the Skype, so I do apologize for that. That I've admitted to being within the state of Arizona. I said, no, I'm in Arizona. I have the fortified compound in Mesa, Arizona, but I'm not in the state. The state didn't exist in 1912, but I can guarantee that the land that I'm on was here in 1911. So. But the state wasn't. The state is obviously a fiction. It's obviously a corporate body, and so why did this guy just every single comment?
It's hard to keep it all separate, right?
Well, I think it's easier.
Anyway,
sorry.
I said anyway. Maybe we should get to the reason I phoned here. Like, I just wanted to gloat a little bit. I wanted to say, here's another success story for Mark's stuff here. So, this is proof right here. This was, the cop pulled me over, gave me a speeding ticket, a fine, a violation. So I gave him a violation. So they didn't think that was proper. They thought that was some sort of intimidation. And I said, well, I don't know how much less intimidating I can be than writing some words on a piece of paper, you know, like, right? So basically, I just followed the Socratic method, and you're right. I mean, in the end, they played it all tough, and they made me sound like an idiot on the news. But in the end, that's what it was. The judge, when I asked the judge if I was innocent of all the elements of the charge, and he said, well, yeah, you are. You know, he thought about it for a second. He paused, and I said, well, is jurisdiction one of the elements? And then he thought about that for a second, and he said, it is, but we're assuming jurisdiction. And he gave his reasons or whatever. He talked about it. He gave a big diatribe about Canada's history and stuff. And I was basically in the back of my mind going, well, I don't see any evidence yet. So, right.
But wait, Alan, he used the word assuming.
Yeah, he did. Yeah. He said that we're assuming jurisdiction. He said it's inherent jurisdiction. And I actually had a chance to study about inherent jurisdiction the weekend, because the jury trial judge kind of tried to pull that on the way out. He said, oh, we have inherent jurisdiction. So
inherent jurisdiction based on what? Oh, objection based on what, sir? On what?
Well, you know, I looked up the concept. I understand the concept of it, but under their rules, even, it says that they can't use it only for special cases, for civil court only, right? Not for criminal court. So.
Okay, anyway, well, I'm almost out of time here because I've actually gone way over time. So how does this end? I mean, they tossed it out?
Well, basically, you could see it. He was sweating it. He realized he made an error, and he convinced the prosecutor that they probably didn't have enough evidence anyway, right? So, but he knew it. He made an error. He said that they're assuming jurisdiction. He basically said that, you know, he basically admitted on the record that Canada's a tyranny and they're just using force, right? So. They convinced the prosecutor. I think he convinced her to get rid of the case. And I went for lunch, came back, and they just stayed the charges. So
nice. Well, congratulations. So, yeah. You have that in writing?
Yeah, facing. Well, it's coming. Yeah, it'll be in the mail. It's facing 14 years. That's scheduled 7-day trial. It took care of it in an hour and a half, and it was done at lunch. I had enough for an appeal within an hour and a half. And they knew it. I even told them that. When we went for lunch, I said, well, you know what? I got enough for an appeal, so you guys do what you want. So they probably listened to it whether I'm lunch, and they said, yeah, he's right. What the hell are we doing here, right? So, but of course, you know, they're not going to stay out in the public what actually they're not going to justify what I'm saying. They don't want people to know about that, because, you know, what if hardened criminals start pulling that shit, right? Then they're going to have a real problem.
Well, they can just deny it like they do in so many other cases. But hey, congratulations, man! I appreciate that. Thanks for letting me know.
Yeah, and it's all because you're the man, Mark. You are the big show, bro.
Well,
everybody here, everybody that can hear that, Mark is the show.
Well, it's using logic and reason. That's what it is. Refusing to accept the sacred cow, and not being an apologist for a violently immoral system like these lawyers tend to be, and just actually trying to be more morally consistent. So I appreciate that. That's great. I'm looking forward to seeing the documentation.
And I thank you for everything that you do, Mark. I mean, and like you say, you just gotta stop taking it from them. You just stand up and say, hey, you know, like, where's your evidence? I mean, you guys are assuming a lot here, and this is really imposing on my life. So, you know what? I'm gonna start asking questions, and if you guys can't prove anything, then you're out to lunch, okay? So the people are sick and tired of it.
Yeah, hopefully there's more people that are tired of that. Look, I got to wrap up the show, but I appreciate the call.
Yeah, peace out.
All right, appreciate it. It's Alan in Canada. another big success story that, and that's what it comes down to is we can't accept sacred cows. You can't just say, oh, it's the government, I shouldn't challenge it, or they have legal logic and circular logic applies. They use legal circular logic. They're not going to let me talk in circles and accept that. You could give them black letter law. That an adversarial proceeding, according to them, requires true adversaries, and that requires an actual, honest, antagonistic assertion of rights based on evidence. They don't accept it. No, what this lawyer means is that they accept circular logic when it helps them to prosecute you. You and I do not go into and argue in a circle and have a judge say, that's sound legal logic there. Wow. No, if you are in a system that accepts circular arguments as valid proof, you are dealing with crooks. And what else can you expect? Alan just reported that the judge said he was innocent, presumed innocent of all the elements of the charge. He states that jurisdiction is an element of the charge. Then he has him clarify and be specific that he's presuming that he's innocent, that there's no jurisdiction. And then he uses the A word. We're going to assume jurisdiction. And who is he assuming it on behalf of? The prosecutor, who doesn't have any evidence. And that is the definition of prosecutorial misconduct, to argue without evidence. And again, if it's something that is valid and it's fair to argue without evidence, then you got to let me do it too. But it's BS. And if you're going to champion a system that says that people can make claims against you, that the entire foundation of their case against you needs no support whatsoever, and that they can argue against you in a circle, then what you're doing is you're cheerleading for a group of crooks. And you're making the case for me. Absolute crooks. Well, I got to take a couple minutes and talk about risk management. And I'll talk more about this as we go about this case in Texas. There are no cases that we have gone to the end with this. We only have some people so far that have gone and filed claims for damages with the insurance risk management, and only one of them has gotten a denial at this point, so we'll take that into court. Yes, it's theoretical. We're trying to do something to get these judges and prosecutors off of their gilded thrones there, get them out of their stupid black robe, get them into a deposition where we can ask them questions and they don't have the power of contempt. The idea that to me is the goal, so that we can have a video record of a judge unable to produce a shred of evidence that the prosecution or the cop gave them any evidence, that he was literally doing it because he said so. We want that on the record in a deposition or in court. And it helps that if we could do this in New Hampshire, because you can get cameras into the court. But so far, no one in New Hampshire has done that. They tell us point blank that jurisdiction's a trial issue only. We know they're lying. We know they're lying. So I do have to run. We're totally out of time here. I've gone a bit over. I will be live on the Saturday show. I don't know if I'm going to be streaming. I have the option. I might, if I do stream it here on YouTube, it's definitely not going to be in HD. But we should be able to manage 480, but that doesn't matter. But we're hoping to have a hardcore critic on Saturday. He says he's going to call in. We'll see. But this has been episode 60 of the live commercial-free edition of the No State Project, exclusively here on my YouTube channel. We get this up at markstevens.net today because, hey, I don't have to do any Frank Rizzo 3 on Skype. The email is markstevens@mail.com. Until next time, salud, baby.